from St. Thomas University, Florida, USA. Ma'am is currently working as a project coordinator of Clearwater United for Human Rights Center, the world's largest human rights education campaign, which is actively in 192 countries around the world. Before that, she has served as director, founder principal and faculty member in various institutions in India. She is editor-in-chief of Intercultural Human Rights Law, which is ranked 6th in the world. In the year 2018, she has received Professor John McDessie and Prof. Joan Mary Scholarship for the specialized LLM courses. She authored 5 books, conducted and chaired many national and international seminars, workshops, and conferences. For time constraint, I stop here and hand over forum to Professor Samiya Tabasum to deliver a speech on global alternative dispute resolution system. Over to you, ma'am, please. Ma'am.
Hello. Yes, I really appreciate for Gauri ma'am and team for inviting me to be the part of this virtual conferences, but I am sorry also because it is running late, more than 1 hour, and we are like this. When we start talking, we don't know where to stop without considering the time limit. So it is okay because I had today Saturday, it is morning here in Florida. It's okay. And now my topic is global ADR system, which is very vast topic, but I will be covering some of the countries, including USA and Canada and other countries. I will be showing what are the systems there, and basically for history also. I would like to request host to please remove my PowerPoint slides. I don't need this.
Okay, ma'am, sure.
Okay, because I can do without this thing because I share here dual screen. So I'm really excited that everyone is speaking about their system, which is other than the court. Other than the court, it is not in our India, it is throughout the world. That is why it is alternate dispute resolution system, or here it is also called external dispute resolution, which is often used to describe a wide variety of dispute resolution mechanisms that are short of or alternative to full-scale court processes. ADR systems may be generally categorized as negotiation, conciliation, mediation, or arbitration systems. It is important to distinguish between binding and non-binding forms of ADR. Negotiation, mediation, and conciliation programs are non-binding and depend on the willingness of the parties to reach a voluntary agreement. Arbitration programs may either be binding or non-binding. Binding arbitration produces a third-party decision that the disputants must follow, even if they disagree with the result, much like a judicial decision. Non-binding arbitration produces a third-party decision that the parties may reject. Now, what are the key observations of this ADR system? Because everyone is talking about a worldwide ADR system, we should implement this and that, because it is one and the same thing. Everyone wants out-of-court settlement, whether it is, I was just studying the questions which I received on the screen also. There was good questions also, because time constraint, I wanted to reply those questions, but due to time constraint, it is very difficult to do so many questions. So ADR programs can't be substitute for a formal judicial system. ADR programs are instruments for the application of equity rather than a rule of law, and as such can't be expected to establish legal precedent or implement changes in legal and social norms. However, ADR programs can complement and support judicial reforms. ADR programs can increase access to justice for social groups that are not adequately or fairly served by the judicial system. They can also reduce cost and time to resolve disputes and increase disputants' satisfaction with outcomes in ADR programs. Can support not only rule of law objectives, but also other development objectives such as economic development of civil society, and support of disadvantaged groups, by facilitating the resolution of disputes that are impeding progress towards these objectives. The term can refer to everything from facilitated settlement, negotiation in which disputant or encouraged to negotiate directly with each other prior to some other legal process. The arbitration system are mini trials that look and feel very much like a courtroom process. Processes designed to manage community tension or facilitate community development issue can also be included within the rubric of ADR. Now, if we start, what is the position in USA? We have to go to the history of the USA, where it started. Somehow, I will be giving some of the tips, not to full because it is full of history. In 1770, George Washington places arbitration clause to his will. And 1914 to 18, World War I issues ADR process to resolve labor disputes and establish labor agreements to aid war effort. In 1920, New York State passes first modern arbitration law. And 1976, as everyone is knowing, Bond Conference promotes legal reform by encouraging ADR processes, including multi-door courthouse. And 1990, Civil Justice Reform Act initiate experiment to reform federal courts with focus on ADR use. And one is the one everyone is knowing about the court case which went beyond the court settlement, that is US versus Microsoft antitrust case mediation, which was the case of Microsoft, and it has been done, out of court settlement has been done in 2001. Now, in the United States, at present, many kinds of ADR exist. American lawyers count about 20 different alternative proceedings for settling legal disputes. There are primarily three well-known processes: negotiation, mediation, and arbitration. Elements of these processes have been combined in a number of ways to create a rich variety of so-called hybrid dispute resolution techniques, such as mini trial, early neutral evaluation, mad-up, rent-a-judge, and ombudsman. All of these methods could be described as non-court or private ADR practices. In 1979, retired Judge Warren Knight of California started the Judicial Arbitration and Mediation Service, an organization dedicated to providing law firms, businesses, and individuals with access to judges willing to serve ADR capacities. Now, what are the forms and types of ADR in the United States? The types of ADR available in the United States can be divided into three general categories, which are adjudicative, evaluative, and facilitative. In adjudicative ADR proceeding, a quasi-judicial facilitator called the neutral serves as the adjudicator or decision maker. This participation by an outside impartial third party is often desirable to participate, unwilling to negotiate, yet preferring to avoid formal litigation. Additionally, while adjudication, though the US judicial system always result in a binding decision, adjudicative ADR can provide various results, whether binding or non-binding or advisory. Then comes the evaluative, which is the second category of ADR, is a process in which lawyers and litigants present their version of a particular case and receive feedback on the strength and weakness of their claims and arguments. In many of these proceedings, the parties are not yet willing to discuss a settlement, and evaluation serves to provide context as to each party's bargaining power, both to reaffirm particular beliefs and to dispel unreasonable expectations. Then is facilitative ADR, which is the third category of ADR in the USA. The neutral does not render a binding decision, nor does he. Neutral here is like the arbitrator or mediator, they called here as neutral. Or he or she actually reach the merits of a dispute. Instead, a neutral serves more as a referee or advisor to the parties to encourage discussion, dialogue, and settlement. The three most common forms of facilitative ADR are mediation, conciliation, and consensus building. There is one more Other commercial arbitration, which we called here as structured negotiation, which is a type of collaborative and solution-driven alternative dispute resolution that differs from traditional ADR options in that it does not rely on a third-party mediation and is not initiated by a legal complaint. The process is often implemented in cases in which a party or parties seek injunctive relief. Structured negotiation has been used to arrange agreements that typically arise from would-be American with Disabilities Act ADA legal complaints. The techniques can be contrasted with certain types of lawsuits, often referred to as drive-by lawsuits, where a long strings of lawsuits about the ADR are filed publicly by a single lawyer and settled quickly and confidentially, a practice which can undermine the struggle to adopt more inclusive accessibility practices. Structured negotiation was first used in 1999 to settle the first legal agreement in the United States in which Citibank agreed to install talking ATMs. Here, we use the talking ATMs, this is for the information, because when somebody is not able to operate the ATM, there is the one option on the term machine, there one assistant comes on the screen like I am on screen, and he or she helps the customer how to help the to take the money or to deposit the money on ATMs. This was the case, dealing with the structured negotiation, and was quickly followed by similar agreements with several other financial institutions, including Bank of America and Wells Fargo Bank. Now, what is the position in Canada? One of the first and most notable ADR initiatives in Canada began in 4th January 1999 with the creation of Ontario Mandatory Mediation Program. In 2014, the Supreme Court of Canada stated in Hernack versus Maldine that meaningful access to justice is now the greatest challenge to the rule of law in Canada today. For instance, in 2015, Quebec implemented the new code, which mandated that practices must at least consider mediation before moving to settle a dispute in court. Atlantic, Institute of Manitoba, Institute of Alberta, and Institute of Quebec. Now, what is the position in Somalia? Somalia has a cultural and historic mediation and justice system of ADR, which is an informal justice system. It is a kind of justice system in which the arbiter listens to both sides of dispute and then concludes a solution that both sides will accept. Internationally, the ADR movement has also taken off in both developed and developing countries. ADR models may be straightforward imports of processes found in the United States or hybrid experiment mixing. ADR models with elements of traditional dispute resolution. ADR processes are being implemented to meet a wide range of social, legal, commercial, and political goals. In the developing world, a number of countries are engaging in the ADR experiment, including Argentina, Bangladesh, Bolivia, Colombia, Ecuador, the Philippines, South Africa, Sri Lanka, Ukraine, and Uruguay. Taiwan and China have the best examples of broadly and deeply institutionalized community-based ADR. In both countries, local government officials and well-respected citizens act as conciliators, mediators, and arbitrators for the vast majority of local disputes. In China, arbitration is simply a usually, but not always, private process of adjudication in which parties in dispute with each other choose decision makers, sometimes one, often a panel of three, and the rules of procedure, evidence, and decision by which their dispute will be decided. This is a distinction from a form of mediation in which a neutral third party facilitates party negotiation to resolve a dispute, but does not decide the matters in conflict, and adjudication in which an officer of state, usually a judge, decides a matter according to principles of law that are often but not always published and available for use as precedent by parties other than the principal disputants. In South Africa, India, and Bangladesh, ADR programs were developed to bypass corrupt, biased, or otherwise discredited court system that could not provide reasonably justice for at least certain parts of the population. In Sri Lanka, the reputation of the courts is relatively good, but they were ineffective in resolving many local and small disputes because of high costs and long delays. The mediation boards there have evolved as a substitute for the courts, but enjoy the support of judicial system. Bolivia, Haiti, Ecuador, and El Salvador are developing systems involving government support for independent local informal dispute resolution panels to serve parts of the population for whom the courts are ineffective, arbitration as the primary mechanism for resolving labor management disputes. Most European countries, the Russian Federation uses the civil law system, which was influenced by ancient Roman law. The main distinguishing feature of this system is that legislation is the primary source of law. Court decision must be based solely on statutory law. Unlike US, Russia does not have varied methods of ADR. Arbitration is the most widely used form of ADR and is actively used in commercial dispute resolution. Some Russian state universities have developed corresponding teaching courses for law students, like in the last few years in the legal department of Varanasi State University, students have been taught a special course on ADR. In India, first of all, where the ADR system is first came in our India in 500 BC in the form of Panchayat system. India maintains a hybrid legal system with a mixture of civil, common law, and customary Islamic ethics or religious law within the legal framework, inherited from the colonial era and various legislation first introduced by the British are still in effect in modified form today. Now, seeing the position in these countries, what is my conclusion? Because this is, as we go to the topic of this conference, post-2020, right? Why we are in transitioning period. What I have concluded being here, because I am listening about what is the position in COVID-19, everybody is, uncertainty is there. Nobody knows whether we live, whether we will remain. What is the result of this COVID post-2020? It was posted, and somebody is saying it should be now called COVID 2020, then 2021. So nobody knows, because all of a sudden it came. What is in the present scenario, everything is uncertain due to COVID-19 pandemic, and the world is in transitioning period. This happened unexpectedly. So what will be the court process post-COVID-19? No one can guess. No one is sure of. This pandemic has given rise to different phobias, like one man phobic to another. Even blood relations are maintaining the distance. So everything is unpredictable. So the dispute resolution system. We discussed the law which is prevalent pre-COVID-19 and already exists. But no one knows what this pandemic will take the shape. Worldwide, the courts are dealing the cases through the video conference, virtual conference, that two important cases. So post-2020 or post-pandemic, what will be the shape of the world? Nobody knows. And with this, I conclude this session, and thank you so much, everyone, for
Thank you, ma'am. Thank you.
Thank you.
Thank you, ma'am. Thank you for excellent speech about the history and process of USA. Just one question from our assistant professor Madhumita Veerababu. Can an arbitrator determine what is the proper law is to the case before them when the arbitration agreement is silent about it?
So if we have arbitrator first, we are giving this facility to the disputant or litigant. And we are here, if she is talking about their law here we are giving the chance of the disputant, he or she can assign, she can name the mediator, arbiter. And it depends upon the dispute, whether it is a civil case, it is a land dispute, it is a labor dispute. It depends upon the dispute. And whether he or she wants to settle the dispute out of court. So here it is totally different as compared to India and other countries. Here there is liberty to disputant, whether if there is some person, there is no provision of arbitration. Here there is an act which has been passed in 1976. That arbitrator has to go as per that act. So he or she can't be do the things with his own or her own consent. No, here the act is there, like we have in India also.
Okay, ma'am. Thank you. Thank you. Madam, over to Siva.
Thank you, sir. I hope all the participants would have been benefited by this international conference. The speakers have indeed instilled in us various thoughts on arbitration pre and post 2020. Now I request Mrs. J. Devi, Assistant Professor, Chennai Dr. Ambedkar Government Law College, Pudupakkam, to deliver the vote of thanks.
Thank you, Hepsi. Good evening, all. Arbitration is a sensible suggestion which it is worth discussing. It is now my pleasant duty to propose a vote of thanks on behalf of Chennai Dr. Ambedkar Government Law College, Pudupakkam, to all the dignitaries who have witnessed it as a memorable and successful event, that is Arbitration Post 2020. Today, my words are not enough to express the gratitude. First of all, I would like to take this opportunity to thank His Lordship, Honorable Justice Thiru M. Sundar, Judge, Madras High Court, for sparing his valuable time to be with us this evening. His Lordship graced us with his thought-provoking address on Challenge of an Arbitral Award under Section 34 of the Arbitration and Conciliation Act 1996, which have set a perfect platform for our college. We are really enlightened with your knowledge and presence, Your Lordship. The questions were very much encouraged, appreciated, and patiently answered by His Lordship. I sincerely extend my heartfelt gratitude to Your Lordship. I would like to extend a very hearty thanks to His Lordship, Honorable Justice Thiru Jayachandran, Judge, Madras High Court, who graced us with his presence. Thank you, Your Lordship. I would like to extend a very hearty vote of thanks to our respected Law Secretary, Thiru C. Gopi Ravish Kumar, for your thought-provoking inaugural address, sir. Thank you, sir. I extend my gratitude to our beloved Director, Professor Dr. N.S. Santosh Kumar, sir, for his continuous encouragement and moral support in each and every occasion. I thank you, sir. Next, I take this opportunity to thank our most respected principal, Professor Dr. Gauri Ramesh Madam, for her valuable guidance, encouragement, and moral support in making this event a grand success. I am very grateful to our principal, ma'am, for giving us an opportunity to organize this event. I thank you, madam, for your excellent welcome address. I would like to thank our distinguished speaker, Professor Dr. Yusuf Farah, for his wonderful lecture on testing the impartiality of an arbitrator against the values of legitimacy and efficiency in international commercial arbitration. Sir, you have delivered an excellent presentation and making this conference in a very meaningful and interesting, sir. I once again thank you, sir. I thank Dr. Nathalie Najar for her exemplary address on arbitration and COVID-19. It was really a wonderful and marvelous lecture, madam. I thank you for sharing your valuable knowledge with us. Thank you, madam. I thank Mr. Inbavijayan Veeraraghavan, sir, for his marvelous and magnificent address on influence of dispute resolution classes in arbitration. Sir, it was an amazing and extraordinary lecture, sir. I once again thank you for such an amazing, mind-blowing session. We are really enlightened with your knowledge and presence, sir. I thank you once again, sir. I would like to extend my sincere gratitude to Mr. Anirudh Krishnan for his lecture on India as a seat of arbitration. Sir, we were enormously benefited and enriched in knowledge by your address. I once again thank you, sir. I would like to extend my heartfelt gratitude to Dr. Samiya Tabasum for her lecture on Global Alternative Dispute Resolution System. It was a wonderful lecture, madam. Thank you, ma'am. I once again thank all the distinguished panelists. I thank all the principals from various government law colleges, Professor Dr. A. Vijayalakshmi Ramalinga madam, Professor Dr. Jayagauri ma'am, Professor Dr. Tangaramani madam, Professor Dr. S. M. Balakrishnan sir, Professor Dr. Durga Lakshmi ma'am, and Professor Sivata sir. I thank all the principals who have blessed us with their presence. Thank you, principals. The proceedings of the conference were seamlessly and successfully moderated by our assistant professors, Mrs. V. Rekha, Ms. V. Madhumita, and Mr. V. Shyam Sundar. I thank them for making question and answer session in interesting manner. I thank Mrs. D. Kritika and Mrs. C. Hepsiba Beulah for their technical support. I thank my colleague, Mr. K. Subhash Chandra Bose, and all the assistant professors, Mr. S. Arogyam, Mr. S. Ashok Kumar, Mrs. Brinda Devi, Mrs. K. Janu, Mrs. V. Vijayshri, Mrs. Mano, and Mrs. Ramya. I thank them for their continuous encouragement and moral support. Finally, I thank all the wonderful participants who have turned up in such a great numbers. I once again thank everyone whose contribution has made the event a successful one. Thank you all.
Thank you, ma'am. Arbitration indeed is a sensible suggestion which is worth discussing, and we agreed today. We move to the end of this event. We request you all to rise up for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल गंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 जय